Subscribe to our YouTube channel and press the bell icon to get the latest updates.
Today's Cut the Clutter, I will talk in some detail about some of the latest happenings in the Supreme Court of India and what their implications are. And also in passing, I will talk about Devendra Fadnavis, who resigns today and who's just held this, I would say, a fairly hurt press conference attacking the Shiv Sena, which is uncharacteristic of him. So first, the judiciary. Now, I'm not sure if all of you have seen the film Jolly LLB 2. But if you did, and even if you didn't, I will tell you, there is a wonderful actor, Saurabh Shukla, who plays the judge in that film. And he usually looks quite cynical and distracted, etc., etc. But finally, when he gives the order, he speaks very important lines. He says, look, everything in this courts is broken, everything is rotten, nothing works here. Even I get fed up. I am tired of coming to work every day to court, and 6 o'clock, I can't wait to go. Because so much is wrong here, things are dirty, etc., etc. But, he says, what happens when two people fight? If two people fight, they still tell each other, I will see you in court. Why? Because they expect justice from courts, no matter how badly run the courts are. Now, therein lies a message, and the message is to the institution. Because what is the judiciary and who is a judge? This is just the moral authority, political capital, institutional capital, constitutional capital. But underneath all this, the first foundation stone is moral capital. So, any institution that is based on moral capital, it has to use that capital very carefully, because no matter how much capital you have, it is still finite. It is not infinite. So, why am I provoked to talk about this week, and what am I decluttering? Two things have happened the last 3 days. I would say in the last 72 hours. One Supreme Court judge under Justice Arun Mishra summoned the Chief Secretary of Punjab and lambasted him and said, you are doing nothing, you don't. I mean, he said many angry and rude things to him over the question of stubble burning. And he said, people are dying, farmers are prospering elsewhere in the world, why can't they prosper in India, etc., etc. And you give so much money to the farmers for stubble, and when the Chief Secretary tried to say that they have fiscal pressures, he again got screamed at. Now, so far so good, maybe good headlines, maybe some people, maybe a lot of people applauded it. But there are two problems there. One, is that the court's job? Should the court take over direct governance of a state which has an elected government? Even the central government can't do it. Of course, the court has the power to do anything, the Supreme Court, and I will talk about those powers. Similarly, as we speak today, the Chief Justice of India summoned the Chief Secretary and DGP of Uttar Pradesh, obviously to talk to them, to convince himself that they are sincere about maintaining law and order in the state in view of the impending Ayodhya Babri judgment, which has to come out next week, because then the CJI is retiring. Now, think about it. First of all, only the judges know. The CJI, although there are 5 different judges who will write their own judgments, but I presume they are talking with each other. They know each other's minds. So CJI has an idea what the judgment is going to be. Whether he does or doesn't, even if he did, let me say, he cannot share that with the DGP and Chief Secretary. He cannot tell them, and I expect him, and I am quite sure he hasn't told them what it's going to be and be prepared for this. He is convincing himself that they will look after law and order. So he thinks that by calling them directly and telling them, listen guys, I am telling you this time if you don't do it, last time 1992 you guys failed, I mean your predecessors, not you individually, failed. This time if this happens, there will be hell to pay. All right. But is that what Chief Justice of India should be doing? Chief Justice of India can give instructions to the state government if he wants to. But the way to do that would be to call the government's counsel and say, convey these instructions to your state government, your chief minister, whoever, who will then tell the chief secretary, the DGP, etc., etc. And similarly, A similar action could have been taken in the case of Punjab. Call the state standing council and convey these orders through him or her. That is the correct conventional way of doing that. But if that was done, it would not have got headlines, would not have made impact at that point. So what is this compulsion to make headlines and impact at that point? And what is the downside? Downside is, in Punjab, stubble burning has still not stopped. It cannot suddenly switch off. You just can't go and pull off the main switch. It doesn't work like that, because there are people at the other end. You have to understand the implications of your orders, and you have to see how implementable your orders are. In Uttar Pradesh, for example, now, after whatever order the court gives, suppose the administration fails to control law and order, it may even fail despite trying its best. What will the Supreme Court then do? Will the Supreme Court then say, you didn't follow our orders and charge them with contempt? It can do that, but for people who fail on their jobs, for dereliction of duty, there are laws already. So once again, what are you doing? You are basically risking, you're investing your own moral, political, institutional, professional capital with orders which other people have to implement, and for which institutional structures for implementation are provided in the constitution. Law and order is a state subject. Agriculture is a state subject. Both states have elected governments with their own majorities. Both governments are bound to follow the Supreme Court's directions. The Supreme Court should give them directions, not try and take this over directly. But this is a little bit of a weakness, or I would say temptation, that is built in for some time, that things are so wrong everywhere that I have to do something about it. And there are laws under which this is done. There is Article 32, which is right to life, under which a lot of the environmental activism is carried out. But there is also Article 142 of the Constitution, under which Supreme Court can pass any order in any area where it thinks that under the current laws or current system, complete justice can't be done. So Article 142, please read up on that and you will see the text behind me. That article basically says that Supreme Court can pass any order to make sure that complete justice is done in a particular case. Then it doesn't matter what the current law says, because that order becomes the law. Now again, why does the Supreme Court have this power? The Supreme Court has this power because Supreme Court has again that triple capital, that three-pronged institutional capital: institutional, political and moral capital. It has to use that very carefully. Now it has used it several times in cases where it finds, for example, a couple can't get along, they've been going on at each other for 17 years. So Supreme Court takes an action and says, look, this has gone on too long, I am now doing complete justice. To use it in situations like that is fine. Once again, to use it in a situation like, say, Babri Masjid demolition case. The case had gone on for 25 years in a court in Raebareli. Nothing was happening, the cases were dying. So the Supreme Court used its special powers under Article 142 in January 2018 to revive the case against L.K. Advani, Murli Manohar Joshi and Uma Bharti, and said, no, whatever happens, heavens may fall, but the law must be followed. And they transferred these cases to a court in Lucknow asking for speedy trial. That again is good use of institutional, moral, political capital. The court also used the same law, for example, in the Union Carbide Bhopal case, when it gave that award of $470 million to the victims in Bhopal, which most critics think, and now I think increasingly people think, was too small an order, too small a compensation, and that Union Carbide got away too cheaply. But that was also done using Article 142, because Article 142 for the Supreme Court of India is like a nuclear weapon. It is the Brahmastra, it's the final weapon. After that, there is nothing. Nobody can do anything about it unless Parliament then passes another law. So once again, that was controversial, but it was used in a case which had carried on for some time. Maybe the award could have been much higher, but there was some reason for doing that. But then you have some, in my view, some cases which are quite tricky. For example, the Shahid Balwa case, Remember, he was an accused in the 2G case. Now, there the court said that, look, this is going on too long, you guys are going to courts. Now, every Indian citizen has a right under Article 226 of our Constitution. That's the right to file a writ petition in a high court, not in a Supreme Court, in a high court, saying that in lower courts I am not getting justice, my fundamental rights are being violated, so I am coming to high court. That is 226 of Article 226 of the Constitution. That's a right of any citizen. The Supreme Court said, using Article 142 to see that full justice is done, that none of the accused in the 2G case will have any access to high courts, any access to the option of a writ in the high courts under Article 226. I don't think it was a good decision. And it's not as if it made sure that the guilty were punished or trial process was faster. Ultimately, everybody got acquitted. As of now, everybody is acquitted in that case. But what happened? The Supreme Court itself, in its patience and anger, in a way, I don't want to say subverted, but short-circuited the constitutional processes which it is itself supposed to protect. So, it's like, all the laws are there. I am the sheriff of the city. It's my job to protect the laws. But because I am the sheriff, I can order any law to be broken as I wish. So, it was a bit like that. Again, say the coal mine allocation case. Again, a 2014 order. Those were the years of scandal mania. Again, the Supreme Court used the same doctrine, 142, and said that every coal mine allocated since 1993, so that is since 21 years back, will now be cancelled and will be rebid. Now, there was no evidence at all, there was no inquiry that any of those earlier mines had irregularities in their allocation, and yet everything was cancelled. What is the result? The result is your coal sector is still a wretched mess, your power sector is a mess. That part of India's economy hasn't recovered now. It's been almost 6 years since that order. Once again, it was an order passed in fury, anger, fury, outrage, maybe, not maybe, in fact, certainly very justified. But remember, the courts are not supposed to get angry. Judges are not supposed to get angry. Judges are supposed to be patient. In any case, as the old saying goes, one who wields the big stick must speak softly. But in this case, that hasn't happened. And there are many other cases. Highway liquor ban, that you cannot sell liquor or serve liquor within 500 meters of a highway. Once again, using the same powers. What happened? That order was unimplementable. Just like I would say the order on stubble burning. These are unimplementable orders. Institutions that value their moral capital should not give unimplementable orders, because once people get used to defying those orders by saying, I just can't do it, then it becomes a practice and people stop taking you seriously. That's why you have to use these powers very, 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 very carefully. You want more examples? The Committee of Administrators in BCCI, which fortunately is now gone, forgotten. They've taken their tribute from BCCI of several tens of crores overall, and they've gone. But in July 2017, they came to Supreme Court of India, to the cricket bench, and said, use Article 142 to empower us to rewrite BCCI's constitution and also order the Tamil Nadu Cooperative Societies authorities under which BCCI is constituted as a society to implement it and accept it right away. So again, Supreme Court of India used that power, which is to be used so exceptionally, in something in which they had got willingly, they just got drawn. It became like something that I don't want to say an ego battle, but it became a bit of an izzat ka sawal. But the fact is, we know exactly what has happened with the BCCI, who's in charge. After all the so-called reforms, the family members, children, children-in-law of the same people have come in, and it's actually effectively a restoration of status quo ante. So in all these cases, I would say, barring the first two that I mentioned, including the Babri case, Supreme Court, I think, frittered away some of its moral capital by doing this, which is what it is doing now by summoning these chief secretaries. Because if this goes wrong, who will be to blame? Because tomorrow the chief minister of UP can say, what can I do? My police and my administration were taken over by the Supreme Court of India. Tomorrow, stubble burning doesn't stop in Punjab. Chief Minister of Punjab can give a speech. Now, my Supreme Court has given an order to my Chief Secretary. They can send him to jail. Will you send him to jail? If you think this is not enough, I will tell you more of this is happening, because once it comes from Supreme Court, it spreads everywhere. National Green Tribunal, for example, has given an order. I have read it in detail. It's a bizarre order. It's one of the most bizarre things I have read. It is also so muddled and so convoluted. It's an order about conservation of fresh water. It says, on the one hand, that too much groundwater is being taken out by bore wells. Okay. It also says, then it basically goes into another direction, which is the use of RO, which is the reverse osmosis units, which most of our homes have these days, for cleaning our water. And then goes on to say that by doing that, a lot of fresh water is wasted, which is wrong. Also, ROs take out all the minerals from water. So, even if you use RO, you have to put some minerals back. And it has ordered Ministry of Environment and Forest to notify a ban on the use of ROs. I mean, more or less a ban. They are allowed in some circumstances. Now, is such a thing possible? Is such a ban enforceable? And because the ministry has not been able to enforce it, now NGT has said that by a certain date in January 2020, that is 2 months from now, if you haven't done it, we will instruct the government to stop paying you your salaries. Can you imagine a Ministry of Environment and Finance guy coming to your home and saying, why are you using an RO in your kitchen? It's not going to happen, because we are all using ROs and our filters, etc., because we don't trust our municipal water. Can the NGT make sure that every municipal corporation in this country gives you water that you can trust and you can drink? Is it the job of judges to make sure that there are enough minerals, calcium and magnesium in your water? I promise you this order will not be implemented, just as the order of banning bore wells has not been implemented. So, my short point, if you keep giving orders in fury, in anger, for grandstanding, for headlines, like the Pataka order, then you have to see, is it implementable or not? Because if you give orders, get the headlines that day, and then orders are not implemented, then the next one is not implemented, then the next one is not implemented. It becomes the opposite of a virtuous cycle. It becomes a vicious cycle. People then begin to get used to defying court orders, because there is safety in numbers. How many people will the Supreme Court send to jail? Who will take me to jail, right? So, courts have to use their authority and their powers very sparingly. I do think respectfully that the Supreme Court erred in summoning both these sets of officials from Punjab and Uttar Pradesh, because these are setting bad precedents and there will be consequences. Now, that is about the judiciary. Second, the passing, I said I'll mention about Devendra Fadnavis, who was going away. When he had become chief minister, I had said something about him. I had said that he's an unusual politician in Maharashtra who doesn't have any of the three assets or liabilities that almost every politician in Maharashtra has. What are those three? One is a sugar mill, second is a cooperative bank, and third is an educational institution. Most Maharashtra politicians have that, and that leads to corruption and vested interests and crossed wires, etc. He did not have any of those. He was a young, clean, soft-spoken, accessible, polite politician. In my view, a pretty good chief minister for 5 years. He's only 49. It's regrettable that somebody as well-intended as that, and somebody not personally corrupt and personally caught up in any of these funny businesses, 3 funny businesses in Maharashtra, has had to go. But I think he set up a good example. And there are not many politicians who qualify, who fit in the same category of not having a finger in one of these three businesses. I would say even Nitin Gadkari, who's from the same city, Nagpur, is one of those. He doesn't have a cooperative bank or a sugar mill or an educational institution, but there are very few of those. So I do hope that Maharashtra, which has had a bad history of corrupt politics and too much quid pro quos here and there and nexuses, I hope it doesn't go back the same way.